Welcome to the 2025 Tribal Healing to Wellness Court webinar series. My name is Angie Juarez-Monger, and I'm a Wellness Court Specialist with the Tribal Law and Policy Institute. Thank you for joining us today for our webinar, Guiding Principles and Recommendations for Trauma-Responsive Treatment Courts. I will now turn it over to Chan, Vice President of Policy Research Associates, to get us started. Chan?
Thank you, Angie. I appreciate it. And I'm presenting today on behalf of Policy Research Associates, which is as Angie just said, the company for which I'm one of the vice presidents. I'm actually a vice president of our criminal legal system program area. So I wear a few different hats in that role. But the main hat that I wear is as director of SAMHSA's Gaines Center for Behavioral Health and Justice Transformation. So if you're familiar with the Gaines Center, that's my main role. And the work that I'm going to be talking about is work that has been and is continuing to be developed as part of our SAMHSA work, our Gaines Center work. But I'm presenting on behalf of Policy Research today because I'm going to incorporate some of the work that we've done as an organization as I talk about especially some of the examples that I share that I'll be sharing in the context of some of the recommendations and guidance that are in this publication. So kind of doing dual duty, but not officially representing SAMHSA today, but rather representing Policy Research Associates. So I just wanted to make that clear as I jump in here. For the learning objectives for today's session, there are essentially three main learning objectives. I'm just going to minimize. There we go. Understanding the importance of incorporating trauma-responsive policies and practices into your treatment court, strategies for implementing the recommendations for a trauma-responsive treatment court in your jurisdiction, and being able to list, although I'm not going to test you, but list the key principles of SAMHSA's concept of trauma and guidance for a trauma-informed approach. And if any of you happen to be at the All Rise conference in Orlando just a couple of weeks ago, it seems like it was a long time ago, and happen to catch our presentation on this topic, you'll hear a lot of the same information, but some new information, especially some of the examples I'm going to share. And like Angie said at the beginning, if we have time for questions, I'm happy to take some questions, but otherwise I'm happy to respond to any questions you might have afterward if we do end up running out of time. So let's dive right in. So the current work that I'm going to be talking about builds upon the publication that you see there from 2014 entitled SAMHSA's Concept of Trauma and Guidance for a Trauma-Informed Approach. From this work, there are sort of two main substantive areas that really drive the work that we're doing. The first is these 6 key principles of a trauma-informed approach. So everything that we're going to talk about today in terms of recommendations for a trauma-responsive approach and implementing trauma-responsive approaches in treatment courts is going to be rooted in these 6 key principles or incorporate these 6 key principles. And we're going to be talking about our recommendations across these 10 implementation domains. And actually, specifically, I'm going to be talking about recommendations for the first 7 domains. So the 10 domains that are described in the publication are classified or grouped together based on their contributory relationships to a 3-step process for implementing trauma-informed and trauma-responsive approaches. So the first 3 domains that you see there review sort of the bigger macro level conditions within an agency or system, identify organizational operational strengths and deficits in current policy, procedure, and practice. The next 3 domains, 4 through 6 that you see, provide guidance on the development and introduction of these approaches. So the first 3 are about reviewing, the second 3 are about development, and then the final 4, and like I said, I'm really only going to focus on the first one, the training and workforce development domain, focuses on then supporting the implementation and ongoing provision of trauma responsive policies and practices. I just want to give a brief overview of what went into developing what I'm going to talk about today, because I think it's important that people who are going to be using this information understand where it's coming from. And I like to think we did a pretty good job of getting people together from sort of all different perspectives across all different types of treatment courts, adult treatment courts, to really inform this publication and to help massage really a lot of the recommendations that I'm going to be talking about so that they're general enough to be applicable across various treatment court settings, but also specific so that people who are using this information really know what to do or get a very good sense of what they need to do if they want to implement these trauma responsive policies, practices, procedures, et cetera, in their specific treatment courts. So, I think we can all agree that, treatment courts share a basic understanding of their collective goals, but I think we can also all agree that there's tremendous variation in the operational realities of treatment courts. And all of these may pose challenges to the adoption of a trauma-informed and trauma-responsive treatment approaches. Recognizing that many treatment courts have already adopted trauma-informed practices and are seeking additional guidance on how to enhance current processes. We at Policy Research Associates, through our work with the Gaines Center, in partnership with All Rise, embarked on a project whose goal was to gather sufficient data to support the drafting of guidance and a set of recommendations that would integrate SAMHSA's 6 key principles of trauma across the first 7 implementation domains for targeted application in treatment court settings. So if you take a look at, if you're familiar with the SAMHSA publication, you know that it is not a publication that's specific to treatment courts, nor is it a publication that's specific to criminal legal system organizations. But all of the implementation domains and the guidance that's in there are general enough to be applied across many different types of organizations in behavioral health and criminal legal and all across the spectrum. So what this publication that I'm going to talk about and these recommendations I'm going to talk about were our attempts then to take those implementation domains and develop recommendations and guidance that would be specific to adult treatment courts. So that's kind of the lens that we're looking at this through. And the way that we developed it started with a virtual expert panel that we hosted in May of 2023. And some of my esteemed colleagues at TLPI were part of that expert panel, which I'm very happy to have had their input in this process. And those folks were asked to participate in a virtual expert panel. And for most of the discussion, we're divided across 5 different treatment court roles, kind of primary roles. So we had groups of judges, groups of court administrators, groups of attorneys, so prosecutors, defense attorneys, clinicians, clinical staff, case managers, and peers. The professionals that were in each of these groups were asked to develop recommendations for implementing the key principles within 3 of the 7 implementation domains. So we tried to assign implementation domains to the different groups as they would be most appropriate to weigh in on. So not one group weighed in initially on all 7 domains, but eventually all of those roles had input into those domains prior to the publication being drafted. So once we held that expert panel, we developed a draft publication or a draft set of recommendations that we presented in a couple of different ways at the All Rise conference in 2023 in Houston. So if you were there and you participated in one of those sessions, your intellect and your contributions are going to be reflected today. And I thank you for that if any of you out there were at one or both of those sessions. So during both of those sessions, we introduced and discussed the recommendations. And then using a structured feedback mechanism technology, we were able to gather information from the participants in those 2 sessions about both their reactions to the recommendations as well as anything we may have missed or anything that needed perhaps further elaboration. So in all told, so across all 3 of these efforts, the expert panel meeting and the 2 sessions at the All Rise conference in 2023, we received feedback and recommendations for about 200 people, 200 treatment court professionals, and that was used to develop the draft report. And then when the draft report was done toward the end of 2023, we circulated the draft to a smaller group of approximately 20 targeted treatment court professionals, half of whom had participated in the expert panel, the other half who had not. And we, in particular, wanted that group of individuals to pay special attention to elicit additional content and recommendations for other subtypes of adult treatment drug courts, so impaired driving courts, veterans treatment courts, and healing to wellness courts, to ensure that any special considerations or recommendations for these types of courts and for the people who they serve were also included in this report and were featured as needed, especially when there were special considerations for the implementation of some of what we're recommending in those settings. So the recommendations then that I'm going to discuss today after that process were also piloted by two cohorts of participants in our Gain Center Learning Collaboratives on this topic. And then we actually released the draft recommendations as a webinar supporting document last year. And we are hoping, I just got back our last review on the document from SAMHSA leadership. It's going to the last level of review with the highest level of SAMHSA leadership. So we're anticipating that we're actually that the publication is going to be is going to be introduced and available as an official SAMHSA publication through the SAMHSA store or whatever it may become once the Administration for Healthy America is formed. So stay tuned for that, and we'll make sure that our folks at TLPI who we work with know when that's released and can share that with you and make sure you know about that. So from all of that, 10 general recommendations emerged, and the recommendations were supported by examples of specific strategies for implementation, as I mentioned, across those first 7 domains. So I'm going to provide a brief overview of each implementation domain, especially for those folks who may not be familiar with the publication that I discussed, the SAMHSA publication. And then I'll give I'll review the recommendations that correspond to each of the domains. And then I'm going to provide some examples that primarily come from those 2 cohorts of treatment courts that I mentioned just a couple of minutes ago, who have participated. We've actually convened, I think, 4 cohorts over the last 4 years of learning collaboratives on implementing trauma-informed practices in your treatment court. So the most recent 2 of those cohorts also had the opportunity to pilot some of these recommendations. So I have some examples to share as well. So without further ado, let me get into the slides here. So implementation of a trauma-informed approach really requires alignment with the 6 key principles and a systematic review and comprehensive organizational assessment that's aligned with SAMHSA's 10 implementation domains. Implementation involves change at multiple levels of an organization and must involve key partners of all types and at all levels within the organization. And that's really critical, and you'll see that reflected throughout the discussion today. Users of this information are encouraged to consider implementation of practices that are consistent with local conditions. That's also a very important point, and should strive to work with cross-system partners to modify those conditions as appropriate to allow for broader adoption of strategies that positively transform treatment court settings and interactions. And we'll talk about some of the recommendations and strategies for doing that, especially across key partner groups in the jurisdiction in which the court operates. So just a reminder again, these are the implementation domains. We're going to be talking about the first 7. And so let's go to domain 1, which is governance and leadership. So the governance and leadership domain examines strategies by which treatment court leadership supports and provides guidance for the implementation of trauma-informed, trauma-responsive practices in court settings. Requires that the leadership group really vocalize as well as model a commitment to the 4 key assumptions, which are also known as the 4 R's, which I'll tell you what those are in a minute. But the 4 R's that are at the foundation of effective trauma-informed and trauma-responsive services and supports. So those 4 R's are realization of the impacts of trauma exposure and strategies for enhancing resilience, recognition of the signs of trauma in ourselves and in the persons with whom we work, responsivity that's grounded in knowledge of trauma and its effects, and resistance to language and behavior that may be re-traumatizing. Important in there, and I'll talk about this here. I'm going to switch to the next slide, but I'll talk about this here when I talk about the recommendations. Is also the integration of peer perspectives, and hopefully I'm preaching to the choir here about the importance of including peers in meaningful and formal roles within the treatment court team and within the broader environment in which the treatment court operates and in which participants receive services. And and you'll see this as a theme as it relates to trauma throughout what we talk about as well. The other thing that I want to stress is that although we're talking about leadership here being important, and many people, and rightfully so, focus on really the judge as the as the face of the court and the person who is out in jurisdictions, kind of leading on behalf of the court. But it's just as important to remember that everyone on the treatment court team can demonstrate leadership and can become champions. The entire team can become a team of champions within your jurisdiction about the importance and the need to integrate trauma-informed and trauma-responsive practices into the treatment court settings. So in terms of guidance, so you can read what I said there, but I want to talk about what that means in more detail. So adopting trauma-informed approaches, I think this is really important to start with, does not restrain a court's ability to hold participants accountable for their actions. That's something that I think is really important to say, is really important to remember, and is really important to communicate and reiterate to especially folks who are a bit skeptical of that. So, probably some of you, I certainly have heard in the past before, well, this is all, we're being soft, we're being, hug-a-thug. I mean, I hate to use that term, but people say that. And that's not what we're talking about. We're talking about being trauma-informed and looking to minimize the impact or the re-traumatization that the court processes and other things that we're asking our participants to do doesn't mean that at all. It means that we're respecting a person's experience and we're respecting the perspective that they have, and we're trying to minimize, like I said, minimize re-traumatization. So some of the things that in terms of what came out of the panels and came out of the feedback that we gathered related to this domain specifically, one was all treatment court roles that were represented really encouraged that in all public-facing communication and documentation, that treatment court officials must acknowledge the impact of both direct and vicarious trauma on court participants. And this includes the perpetuation of stigma surrounding mental health and substance use conditions. Also recognizing how participants might feel overwhelmed after repeatedly sharing their stories, or distressed after hearing about the actions or experiences of others in an open court setting, or impacted by stigmatizing language used during proceedings. So the treatment court team really needs to convey a commitment to providing supports and services to promote safety, and both emotional and physical safety. Treatment court leadership, and again, we're talking about the treatment court team, not just the judge, could enhance internal and external buy-in among people who have a vested interest by seeking greater representation in the role composition of treatment court teams. So this is, part of that is when we're talking about the importance of peers and formal roles. There was strong support for the inclusion of treatment court team members with specialized expertise in those courts, focusing on the needs of specific populations. So again, when I talked about, generally we have these recommendations, but we know that in healing to wellness courts, in veterans treatment courts, and in other types of courts, there are other considerations and there are other experiences of trauma that people bring with them, both personally and because of the circumstances of the communities in which they live, in which they've been raised, in which their parents and their ancestors, were raised and had experiences that resonate still with folks, with participants in your courts today. Treatment court leadership needs to demonstrate its support for people with trauma histories by encouraging and affirming a participant's right to self-determination. So when we talk about, creating treatment plans and talking about terms and conditions of participation, making sure that the individual is considered and the individual has voice and the extent to which possible choice, and feels that support to be an active participant in their participation in their treatment and in the services and supports that they receive. So let me give you some examples from some of our learning collaborative teams that hopefully will be helpful in kind of putting what I'm saying here into context. So I have three different examples to share with you here. The first is from Alameda County, California. And in that jurisdiction, the presiding judge is seeking Judicial Commission approval to read a script at the beginning of each treatment court session. The script thanks attendees, warns attendees of potentially distressing content, and gives attendees the option to step out as needed. It informs participants of their right to choose how they address the court. So, for example, they give the participant the choice if they want to address the court sitting or standing. It describes attorney roles to increase transparency and reinforces the court's goal of justice and fairness. In Mecklenburg County, North Carolina, they developed a training plan for incoming judges in anticipation of turnover due to elections and judge turnover. And, as we all know, in different jurisdictions, there are different ways of appointing judges, of rotating judges. There are different terms. A lot of our treatment courts, have longer terms for the judges who preside over those courts, but not all do. And so, oftentimes the goal and the efforts to implement some of the practices that we're talking about can be very effective until we get a new judge, right, or a new set of folks who make up the treatment court team. So it's really important to do that kind of legacy planning and training as well, so that new judges who come in also understand the importance of being trauma informed and trauma responsive, and also understand some of the aspects of implementation. And finally, Milwaukee, Wisconsin, they trained several judges. Well, I should say, I actually trained several judges several years ago as trainers on trauma-informed responses. And those judges regularly co-train with other criminal justice and behavioral health system partners in their communities, and also host their own trainings for their own peers, their own judges, and others. And I think that's, again, a really important and valuable tool that can be used in jurisdictions. If you have judges who are really on board and gung-ho with what we're talking about today, they're probably the most powerful at engaging the fellow judges. So it's sort of unique. We don't have a lot of examples of that, at least from the work that we've done. But certainly in Milwaukee, there are several judges there who have over the years been really out there championing the work that we're talking about today. All right, so the next domain that we're going to talk about is the policy domain. So this domain focuses on the formal public communications of the treatment court. Strategies related to this domain require a systematic review of current policies, procedures, and practices to determine how best to implement trauma-informed concepts and approaches within the existing treatment court framework. The discussion of this domain also provides guidance on the development of written mission statements, operations manuals, policies, and procedures that document a new or strengthened commitment to the principles of a trauma-informed approach. So in terms of guidance, the guidance is sort of twofold here. The recommendations that we're making are twofold here. One is that written policies and procedures should acknowledge the prevalence and impact of both direct and vicarious trauma on treatment court staff, and participants should aim to ensure a broad range of background and perspectives in the composition of treatment court teams. The other recommendation or main recommendation under this domain is that targeted documentation for treatment court staff and participants should be accessible in a variety of formats, provide clear but flexible rules and opportunities for safeguarding for safeguarding the physical and emotional safety of staff and of persons receiving services. It's important to create and maintain separate documentation for treatment court staff and for individuals receiving services. And it's just as important to create and maintain that for treatment court staff, because I think, again, as we all are acutely aware, our treatment court staff are not immune to the same sorts of things that our treatment court participants are exposed to, hearing people's stories in open court, working directly with participants in the treatment court, and their own trauma that they may bring from both their personal and professional histories into the court. So it's important to be fully trauma informed and trauma responsive. You're looking at all of the people who are interacting with the court, both the treatment court team and other staff and collaborators, as well as participants. Courts should seek to review and modify as necessary policies and procedures to ensure that treatment court principles trauma-informed principles are incorporated, and that they're consistent with evidence-based and best practices and are relevant to all treatment court participants. And there is a general consensus that there should be a review of all of these materials and procedures at least annually. For individuals receiving services, all handbooks, manuals, parole, probation documents should be clear and straightforward, easily accessible in print, online, and oral format, and shared as early in the process as possible. Also, having those materials available in multiple languages, especially languages that we know are germane to the participants that are in the jurisdiction and participate in the courts, and should include things that make participants feel familiar with what the materials, with the information the materials are trying to convey. So including quotes, images, and stories that are relevant to all treatment court participants as well. Ensuring written policies for individuals using services are comprehensive and clearly outline standards for treatment court eligibility, acknowledgement of benchmarks, sanctioning options, and parameters for program completion. Handbooks and policy design for court staff should also be user-friendly and easily accessible. Those documents should describe the opportunities for staff training. And we urge courts that this discussion of training should be explicit and specific. So it should define what training is available, what training is needed, what training is mandatory, intervals, cadence in terms of, what training should be done first, a 101 training and then some more advanced training. And what should that look like for members of the treatment court team? So there is an ambiguity in terms of how do we learn more about this stuff, or that there aren't disparities in terms of what information that different members of the treatment court team have at their disposal and to enhance their understanding. Written policy and procedure should encourage broad representation in the role composition of treatment court teams, with a specific focus on greater inclusion of clinicians, peers, people using services, and should also identify roles for an array of partner groups in the planning, governance, policymaking, service delivery, and evaluation of evolving policy and programming. So some examples of that in action from our learning collaborative teams. Again, we'll kick off with Alameda County, California, but they really recognized and embraced the impact of language, and are actively working on a list of person-centered trauma responsive terms to avoid the use of power dynamic language in the treatment court setting. They, for instance, are looking to change the lexicon, change the language. So for some examples, using the term adherence instead of compliance, avoiding terms like dirty or clean test results, and other terminology changes, because we all know that language is important. In the Illinois Administrative Office of the Courts, which oversees 121 courts within the state of Illinois, they revised their policy and procedures. Their standards now include a section on defining trauma-informed and trauma-responsive practices in the treatment courts, in the court settings. In King County, Seattle, Washington, They modified their referral and evaluation process to ensure referrals for program participant referrals receive program details before enrollment so that they have a very clear understanding of what they are committing to by agreeing to participate in the treatment court. And that really supports transparency and recovery, both of which are important in being a trauma responsive court. In the 8th Judicial District of New Mexico, they renamed their program, as other courts have done as well, from drug court to recovery court. And that was a change that really resonated with participants, and it was noted by participants as helping reduce the stigma of their court participation from their perspective. In Boone County, Missouri, they evaluated their program adjustments and committed to using a more trauma-informed approach. So doing things like reducing jail sanctions, undertaking efforts not to take someone into custody from treatment court, so as to reduce the trauma effects on treatment court team members, as well as other participants and the individual themselves. The 7th Judicial District in Iowa is really working diligently to clarify treatment court roles and boundaries and couch the definitions of those roles and the establishment of those boundaries in both the professional expertise of the treatment court team members, but also with a trauma-informed lens. And then finally, Bucks County, Pennsylvania, we're helping them develop guidance on, provide information and develop guidance on for the team on how to respond to suicide threats and trauma disclosures. So trying to help them better equip all of the people on the treatment court team to respond in a way that is appropriate and is, acknowledges the person's experience, but is appropriate given the information that they're sharing. And that's a really important, I think, aspect of what we're talking about is it's, there are defined roles, there, should be defined boundaries among the different treatment court team members, but it's everybody's responsibility to ensure that the way that the court is operated, the way that, the court and the people in the court are interacting with participants is trauma-informed, and that all members of the treatment court team really understand what that means. All right, so now we're going to talk about physical environment. So with physical environment, we're talking about a focus on assisting organizations in their reviews of the physical and emotional environments of the treatment court setting. A key goal of what we're espousing here is to identify and address elements that may be re-traumatizing for everyone, both court staff and people using services, and to really consider spatial, operational, and behavioral modifications to promote emotional and physical safety in the courts. So within that domain, the guidance that and the recommendations that have been developed as part of this effort really talks about, focuses on a lot on modifications to the physical setting, but also on relational agreements, professional interactions, and with a focus on minimizing triggering occurrences and language and promoting both the perception of safety and the actual safety of everyone in the treatment court process. The sort of core to having a trauma-informed and trauma-responsive physical environment is that the treatment court process should be approachable and safe. And treatment court leadership should consider whether non-judicial professional interactions with people using services could be scheduled for locations outside of the traditional courtroom and possibly even external to the court building. The importance of accessible and affordable transportation within this domain was highlighted as one of the main issues of focus when talking about creating trauma-informed and trauma-responsive courts. And as I think we all are aware, having adequate transportation and having accessible transportation in terms of both being accessible to the participant from where they're coming from, but also having the court accessible via public transportation is an issue that frequently comes up across our different treatment courts across the country. So creating or expanding transportation funding initiatives that are able to lessen the financial burden of individuals traveling to court or to treatment settings. Things like making available, again, the extent to which fiscally possible, bus passes, reimbursement or advance payment for ride shares, and partnerships with local and national organizations to provide some level of shuttle service or some, discounted or free ride share programs. And so that part's important. But then when we talk about the physical setting, um, there's quite a bit. Courts are, I mean, the whole, court process, right, is rooted in adversarial relationships. And from, historically, our courts in general, just the physical structure of our courts are designed to be, intimidating and separating. And so when we're talking about making, especially in treatment court setting, making the court more trauma informed and more trauma responsive, talking about things like creating non-threatening seating arrangements. So a lot of treatment court judges will sit at eye level with participants frequently, or seating of the entire team and the participant around a table. Seating options that allow people to view entry and exit points. And that's particularly important for people with extensive trauma histories who, often need to be able to see, what their, I hate to use escape strategy because that's not the best terminology, but to know where that they can go if something unsafe happens within the court setting, and they can see who's coming and going. That's a really important feature in a relatively straightforward physical environment feature of the court that can be modified. Other modifications of the physical setting to minimize exposure to stimuli in the environment. So trying to, keep the court as calm as possible, the lighting as soothing as possible. The colors on the walls, artwork, especially if we're talking oftentimes about courts where we're dealing with family members also. So having safe spaces for children and others who are related to the treatment court participant. And even things as simple as having tissues available. And again, the language piece is really important. Having signage and other informational materials that are posted available in multiple languages, especially languages that are germane to the populations that are present in the court. And also, though, recognizing that physical changes the courtroom setting, the waiting area, are not always possible. Calming visuals can even be provided through some type of digital display, like a screen or a monitor, showing soothing images or videos on a continuous loop. Um, where possible, trauma-informed practices and trauma-responsive practices in drug testing should be employed. So that includes providing option for participants to choose the gender of the staff member to perform the test, using technology to promote non-invasive testing. And there are some resources on that I can share if that's of interest. But all of those can really enhance participant well-being and safety. Some other things that we're talking about when we're talking about the physical environment are things like creating the possibility of creating a gender-specific docket to minimize re-traumatization of female participants whose trauma may be linked to interactions with male family members or acquaintances. Having mandatory trainings for all court officers on topics such as de-escalation and safe approaches that prioritize physical and emotional well-being of participants. Generating policies that accommodate emotional support animals. Where possible, modifying court officer attire that might be activating. So, oftentimes treatment court judges will not preside wearing a robe. Or having court officer uniforms not be as militaristic or law enforcement looking, and trying to just from a physical a visual space, those things can have a lot of power, and the extent to which those types of strategies are able to be implemented, they can be very powerful, but also very easy to implement changes like that. Careful attention to the content and process of language use. We talked about that before, both in terms of being consistent with the needs of the court participants, and using non-stigmatizing language, and providing space and resources to promote self-engagement and self-care. And that's for the participants and for treatment court teams. So having things available like calming and inviting spaces to serve as waiting rooms for the participant and their families. Having even simple things like bottles of water and snacks and comfortable seating and Wi-Fi, things like that. Those are all, strategies that help and promote and support trauma-informed approaches, and the goal of courts to become trauma responsive. So, in terms of what's going on in the field, some examples. We had three different teams in this current year's Learning Collaborative that I mentioned before that requested, as part of their Learning Collaborative experience, so part of the technical assistance that we provided to them, to have virtual observations of their court by the leadership of our Learning Collaborative, and some of our senior consultants who work as facilitators on that. So that they could observe the proceedings and provide recommendations and their thoughts on, what are they doing well? What could they do differently? What are some of the modifications that could be made? So some examples are in King County, Washington, the observation really focused on intake forms assessments and having stipulated orders of continuance signed upon enrollment, and any other forms that are shared with program participants to reduce re-traumatization. In Vigo County, Indiana, they have a plan that they're in the process of implementing to separate participants based on, I don't love this terminology, but this is their terminology, based on the presence in a person's history of simple trauma and complex PTSD. I would say use your own judgment call with that, but what they're trying to do in that jurisdiction is to essentially match people with what their experiences are, and what some of their treatment needs are and their support needs are in the field. In Alameda County, California, they focused on victim impact statements and the importance of language. So by law, victims have a right to provide a statement in court. So they developed some suggested practices, or we worked with them to develop some suggested practices, including things like 1 week notices, content previews, written submissions with support, emotional preparation for program participants, and strategic scheduling of readings. And in Boone County, Missouri, they made physical changes to the courtroom to increase physical and emotional safety. Things like they removed the podium so that the judge is at the same level as participants, as one strategy. So again, a lot of relatively simple things that can be done when we're talking about creating physical environments that are conducive to supporting people with trauma histories, and to reduce and hopefully eliminate any kind of traumatization or re-traumatization that the physical environment can trigger in court participants. Just gonna have one drink of water quickly. All right, so for domain 4, here in domain 4, we're talking about the engagement involvement of persons in recovery, people receiving services, and people receiving services and their family members. So in this domain, this is really the first of 3 domains that focuses on strategies for developing and implementing and introducing trauma-informed and trauma-responsive approaches in the treatment court setting. So this domain provides an opportunity for an in-depth examination of engagement and involvement, and those are, as we know, core elements of any effective treatment court setting. So Significant involvement, voice, and meaningful choice at all levels was one of the tenets of this implementation domain. So things like involvement, voice, and meaningful choice in program design, implementation, service delivery, quality assurance, addressing community characteristics and workforce development are all important places to seek and incorporate in a meaningful way the involvement of the people who are participating in your courts, alumni of your courts, and their and people who are helping support those participants. One of the best ways to do that is to actively and on an ongoing basis solicit opinions of people in recovery with trauma experiences through a variety of mechanisms, advisory boards, focus groups, suggestion boxes, participant surveys. I mean, there are a number of different ways to do that. And it's not just a one-time thing that we're talking about here. We're talking about building that into the way that the court operates. So having those mechanisms by which feedback can be provided from the people who are participating in the courts and can be used to help inform further modifications to practices and policies and procedures. So in domain 4, what we're talking about in domain 4, we actually have two main recommendations. So there, you see them both there on the screen, but I'm going to talk about each of them a little bit separately. So in terms of the guidance, we know that whenever possible, we want treatment court leadership to introduce initiatives that are designed to expand family and social supports with targeted goals of lessening stress, strengthening resilience, and promoting recovery. And again, within this domain, almost universally among the people who provided the input to developing this guidance or to making this recommendation, again, stress the importance of having that information in terms of how do you do that, come from the people who are receiving services and the people who are supporting them. Demonstration of the respect for the work, educational, mental health, physical health, and childcare schedules of people using services. This can be demonstrated in a lot of different ways, such as authorizing options for virtual sessions that don't conflict with other life responsibilities, alignment of daily court calendars to schedule in-person presence early or late as needed for people with appropriate mental health concerns, limit proximity with others, and avoid activating people, activating events, activating sounds, activating visuals. Providing in-house opportunities for safe and supervised childcare that's accessible at no or low cost. And but there was also a recognition that that costs money to the courts and it costs money to provide those services, as well as issues of space and availability to even provide that if there is funding and support available. So I would say looking at that as sort of an ideal or an ultimate goal as something that is tremendously beneficial if able to be implemented in the court setting to participants and to support their participation. Also designing of welcoming accommodations for support animals, both in the courtroom and in waiting areas, engaging trained peer advocates in the courtroom and waiting areas, both to formally and informally interactions with folks who are waiting to come before the judge and come before the court. And then supporting external efforts to enhance social connections, such as we can use alumni groups for this, or even within the active participant groups. Things like using organizing community gardens, bowling teams, movie nights, things like that. Those are all, again, relatively simple strategies, but they can enhance the engagement and involvement of people who are participating in the courts. And that can go a long way toward compliance and retention with the terms and conditions of their participation. The second main recommendation under Domain 4 is, again, going back to trained and fairly compensated peers having meaningful and well-defined roles in all aspects of court operation, including goal setting and process improvement. Peers should be recognized as core members of the treatment court team and provided opportunities for appropriate professional growth. I think hopefully we all agree. I think we probably all agree that the peer role is critical and central to any recovery process. Um, Communities and individuals benefit from peer and recovery support tremendously. Those services, things like reducing reincarceration, or the impact of those services, have an impact on things like reducing reincarceration, promoting recovery, and improving overall well-being. Um, Peer involvement in treatment courts can counter misconceptions about mental health and substance use conditions, so can really help reduce stigma and educate. And we know that those types of things, when stigma is present and people don't understand the impact of trauma on court participants, that can create further discrimination and lead to further contact with the criminal justice system. So by focusing on individualized strengths-based support, and case planning for individuals in treatment courts, peers can help significantly improve individual and program outcomes. Strategic employment of a robust peer workforce, again, that is well-trained and fairly compensated, and that's critical, was one of the most frequently mentioned aspects of this recommendation. And again, including peers in all aspects of the operation of the treatment, and as meaningful members of the team. There were some cautions that sort of arose from this process. That sort of, I'll say counterbalance isn't the right word, but are cautions within, this robust set of recommendations. So while peer services should be viewed as central, they should be voluntary and not be framed as a condition of compliance with the terms of the court. To grow in their roles as effective advocates and system navigators, peers should be included in all team training, and there should be adequate and appropriate opportunities for mentorship and for supervision for peer staff. And if you're interested in, learning more about peer integration in particular as a core and key ingredient of trauma-informed and trauma-responsive courts, there's a recent publication that we were involved with developing that was released by All Rise last year. I think it came out, that was specifically spoke to the roles of peers in treatment court settings. And it's a great publication. If you're not familiar with it, you can just go to the All Rise website and easily just Google it and you'll find it. But I encourage you, if you're not familiar with that, to make a point of reading that at some point. So some examples from the field in terms of Domain 4 from our Learning Collaborative. So teams across all of the cohorts of the Learning Collaboratives that we've hosted have identified the importance of implementing the voice of the lived experience in their strategic planning and program participant engagement. In the Illinois Administrative Office of the Courts, they started a communities of practice group for peer recovery specialists to get additional ongoing in-service training and networking. The Virginia Administrative Office of the Courts developed a Virginia Specialty Dockets Peer Recovery Specialists Core Values and Competence based on the National Association of Peer Supporters National Practice Guidelines. So essentially, they took some national guidelines from NAPS, National Association of Peer Supporters, and used that to develop their own guidance for all of the courts within the state or Commonwealth of Virginia. For integrating peers into their specialty dockets. Alumni engagement. So there was a lot of alumni engagement in this domain, a lot of activity to engage their treatment court alumni to help further support their participants and help further inform the courts. So several teams across the cohorts are working or have worked with our subject matter experts to develop and sustain a robust alumni network to help support these efforts. In Hamilton County, Ohio, they developed an evaluation program participant satisfaction survey with the assistance of a trained evaluator to help them determine the effectiveness of the treatment court team. In the state of Georgia, they are working on offering programming for women on childhood trauma's impact on parenting and support parent victims through team and family engagement. And if you were at our session at All Rise, where Carolyn Harden and I talked about these recommendations, you may recall that one of the judges from Georgia talked some toward the end of that presentation about specifically about the work that they're doing. And then Bucks County, Pennsylvania is working with our subject matter experts to develop policy and programming in empowering victims team. So a team that is working to help support and develop family decision-making resources and helping support that family decision-making process within the court setting. Okay, so for domain 5, I'm just looking at how I'm doing on time here. Okay, I'm going to go a little bit faster, but these last couple are a little bit shorter. So for domain 5, we're talking about cross-sector collaboration. And when we talk about cross-sector collaboration, we know that the efficacy of treatment courts is often enhanced when there is a shared awareness of reactions of and impacts of trauma exposure. So cross-sector communication and collaboration, we know often result in better assistance to individuals in recovery as they navigate the various physical, emotional, financial, and social barriers. And some factors to consider under this domain include communication with partner agencies, what processes treatment courts could use to share knowledge of evidence-based trauma services with community providers and referral agencies, and the mechanisms in place to promote cross-sector training on trauma and trauma-informed approaches. So in terms of guidance, what does that mean? So we know that both within the treatment court team and within the broader treatment or within the broader community in terms of key partners, a relationship between the treatment court and the external community providers and referral agencies is critical. Hold on just a second. Okay. Forgot to mute my Teams before I did this, so bear with me just a second as I close that out. So we know that within the team, this domain or these recommendations really call for increased opportunities for all treatment court members to share their insights about a person using services. The expertise of some treatment court team members was not regularly or adequately solicited. That was noted as a frequent deficit or barrier, and some suggestions within the team to address this deficit in terms of how that deficit could be corrected were providing mechanisms, safe and secure mechanisms like encrypted email exchanges, or opportunities to have conversations at scheduled team-wide meetings to discuss cases prior to the finalization of any reports. And a note in terms of between stakeholders or within the broader stakeholder group, the external to the treatment court team, the importance of ensuring that community treatment providers were also embracing trauma-informed care and their interactions with individuals and their families was important. And we can't make the assumption that our behavioral health providers are operating in a trauma-informed way. So that's an important function that the court can also support in a community when we're talking about cross-sector collaboration. And there are a lot of different ways to do that, both informally and formally, but the court can take responsibility for making sure that the agencies to which, or through which people are receiving services do have appropriate programming. The services that they provide and in the way that their organizations are run in a trauma-informed manner, and that there are trauma-specific treatment services that are available to participants. And that can be done informally through partnerships, more formally through MOUs, and through contracting processes with treatment providers who are contracted to provide services on behalf of court participants. Those contracts, those RFPs can mandate that both, the agencies operate in a trauma-informed way and have the appropriate array of trauma-specific services available. Also holding regular meetings between treatment court staff and providers to reach consensus on what are the general signs, effects, and responses to trauma. The extent of allowable information sharing, which is, of course, pursuant to the federal confidentiality laws and regulations, and substantive information sharing specific to an identified person using services, how to do that and how to do that in a way that's effective, but also, adheres to the law and to the regulations. All treatment court team members, community providers, and external partners should be knowledgeable about law and procedural rules surrounding information sharing. And all involved parties need to understand what it means to be and then be compliant with HIPAA as it applies to them, and 45 CFR Part 2 regarding substance in guiding the process and substance of exchanges of information that are relevant to the participant's health status. Periodic review of mission statements and strategic plans of the provider or the agency was suggested by many folks who provided input to these recommendations as an important mechanism for assessing the ongoing commitment of the employment of trauma-informed approaches. Also, things like having a member of the treatment court team visits treatment provider agencies. And one of the, again, this is where the treatment court and the treatment court team can really take a leadership role within the broader stakeholder community. Visit the provider agency to gauge how easy and accessible their services are to participants, and if they truly are adopting non-traumatizing elements in the intake process and the design of the physical environment. Even some suggestions around conducting trauma-informed audits or really kind of environmental scans or process assessments. I mean, there are a lot of different things that you can call it, but really taking a holistic look not only at the treatment court process, but the whole process and the broader stakeholder group. Because as we know, even if we have a treatment court that is tremendously trauma-informed and very trauma responsive, that person is still their experiences are still colored by the other experiences that they have across the array of different interactions that they have, both within the criminal legal system and within their treatment and other stakeholders within the universe of who they have to deal with and what they have to deal with as treatment court participants. Some of the ways that you can engage and ensure cross-sector collaboration is development of advisory boards, developed some specific recommendations for healing to wellness courts. Consideration should be given to broad participation by tribal liaisons, possibly elders, who may be able to assist with the identification of tribal resources, practices, and conditions. And conducting targeted informational sessions during which information about substance use and mental health and impact on families and communities can be presented. Co-sponsoring educational sessions to allow the public to better understand the link between trauma and court participation, general community events with informational tables, public training on trauma-informed care, and really, and we'll talk about this when we get to domain 7, which I will get to, I promise, emphasize the need for trauma training for all internal and external parties. So I'll just give some brief examples because I definitely want to get to our last couple here. But I'm thinking we're probably not going to have time for Q&A, so please put your questions in the pod. And like Angie said in the beginning, I'll try to answer those, and we'll get responses back to you. So in this domain, one court, Mecklenburg, North Carolina, they formed a best practice review team, which is a multidisciplinary team with members from legal, probation, peer support, reentry, the recovery court team, and other community partners to review the recovery court phases and assess how to incorporate recovery capital. In King County, Washington, they began offering life skills classes to community court program participants that are available 2 hours before court, and partnering agencies have agreed to offer community service credit hours for those who attend. The Lumi Nation in Washington State strengthened community engagement, cross-agency collaboration, support, and involvement to ensure the well-being of Lumi families and participants due to historical trauma between Native communities and social service providers. And some specific strategies they used, they held informational community sessions about Family Wellness Court, including its purpose and mission. All right, so on to Domain 6. So Domain 6 has sort of two distinct but related parts to it. The first part is about screening and assessment. So screening and assessment focuses on the extent to which treatment courts provide trauma-informed screening and assessment to participants using services. It also, refers to the process by which treatment courts can provide linkages to trauma-specific treatment or referrals to appropriate trauma-specific services. So it's the screening and assessment, the identification and further exploration of people who are exhibiting possible symptoms of trauma, and then ensuring that there are services available and that linkages are available to those services or court participants. So talk a little bit about, about screening and assessment. So in this screening and assessment domain, we are talking about having appropriate screening and assessment, both appropriate in terms of measures and tools that are used, but also appropriate in terms of timing and appropriateness of who is administrating screening, especially screening tools and assessments. I think an important note, and this was a very important note as it relates to tribal healing to wellness courts, is around the appropriateness and the validation of tools with tribal populations. So I want to acknowledge that up front because that is important. When we talk about screening and assessment, we're talking about screening and assessment and not necessarily focusing on, okay, have those validated tools been validated with specific populations that courts might serve? So I wanted to just bring attention to that. Courts may need to incorporate community-defined or community-informed evidence into their screening, assessment, and treatment processes. The incorporation of traditional practices, languages, and belief systems make those practices more meaningful and effective for use with the target population. In healing to wellness courts in particular, examples may include talking circles, traditional ceremonies, and storytelling being incorporated as part of the treatment court experience. And also looking to adapt tools like the Adverse Childhood Experiences Survey to address intergenerational trauma, or pairing traditional practices like talking circles with validated risk assessment methods. Most assessments should be delivered by qualified clinical staff, but not all assessments need to be administered by qualified clinical staff. So as appropriate, we'll say. And within the scope of law, regulation, and policy, it was noted that results of screening and assessment should be shared with appropriate community providers with an eye toward minimizing the re-traumatization that can occur on the part of the participant from multiple requests for disclosure and telling their stories about their circumstances, their experiences. Assessment and intervention should also be ongoing, and it should be dynamic, not static. So there's no, assess once or and never again, because people's, change over time. People go to treatment. People, are no longer in an acute crisis. There are any number of factors that may contribute to that, but really paying attention to that as well. And I see I'm running out of time, so I want to let me just go through this quickly in terms of some of the treatment considerations. So again, making sure that practitioners use and are trained in innovations that are evidence-based, services are culturally appropriate and reflect principles of the trauma-informed approach, and that there are trauma-specific interventions available, and that they are acceptable, appropriate, and effective for the treatment court participants. The sort of the treatment aspect of the recommendations regarding guidance regarding domain 6 is that those interventions should be multifaceted and culturally informed. Clinical interventions and supervision plans should be delivered by providers who are appropriately credentialed and engaged in ongoing training and evidence-based practices. And again, that importance of having trauma-specific practices incorporated across treatment court operations and trauma-specific treatment services available to court participants. So again, in terms of what are some folks doing? Well, in Mecklenburg, North Carolina, they formed an intake committee to review the intake process from a trauma-informed lens to ensure consistency across recovery courts and reentry programs using the drug court standards established by All Rise. In New Mexico, reviewing and revising language in the participant contract to ensure that partners are in their provider contracts to ensure partners are adhering to delineated responsibilities and tasks with the goals of meeting all of the needs of the individuals served. Again, in the Illumination in Washington, initiating screening and assessment that are tools that are commonly understood by treatment court team members, stakeholders, and participants. And they actually worked with the Tribal Law and Policy Institute on developing and identifying culturally appropriate needs assessments and creating culturally appropriate case plans. Integrating the use of LUMI language in both written and verbal communication. And then last but not least, in our last couple of minutes here, and I do apologize for being a little wordy, but it's training and workforce development. And this is a really important one because people need to be educated and understand, all people who are part of the treatment court process need to understand the importance of the impact of trauma, and then the importance of trauma being trauma informed and trauma responsive. So it should include all staff at all levels. We know that if someone has a bad experience with the court security officer as they're coming into the court, that can taint their whole experience. So really looking at training for everyone. Ensuring that human resources incorporates the trauma-informed principles in hiring, supervision, and staff evaluation, and maintaining an awareness of the experience of direct, secondary, and vicarious trauma among court participants, and making resources and supports available and accessible to participants and to staff. And I could do probably a whole webinar on the training piece of it, but let me just share a couple of highlights and a couple of examples, and then we'll be at time, I think. But again, mandated comprehensive trauma training for all staff is at the core of this, and that it should be integrated into the onboarding process for new staff. Where fiscally feasible, so where there are resources available, having a trauma specialist be a part of the treatment court team. And that trauma specialist can provide that education as well as a lot of other service and support to ensure accepted policies that support a trauma-informed approach are actually being practiced with the sensitivity to the needs of all treatment court participants, as well as with fidelity to the purpose of why the court is doing all of this. So ensuring that not only does the court have policies and procedures that on paper are trauma-informed and trauma-responsive, but then in practice, that's actually happening. And that those written policies and procedures should be reviewed in terms of the policies and procedures that pertain to the professionals who work in the courts, should be reviewed on a regular basis, and in collaboration with human resources, treatment court administrators should pay close attention to employee wellness, perhaps designating a well care coordinator. In terms of staff policy and procedures, all staff handbooks should clearly define roles, responsibilities, expectations, should identify areas of responsibility, expertise, and strength, and emphasize the need for members to constrain practice within their specialized roles as a way of better coordinating and delivering services and supports to clients. And if you went to my other session at the drug court conference last month, we had a very robust session on exactly that, on ethics and the importance of being trauma informed, but also kind of, staying in your lane, but being collaborative in your role as a member of the treatment court team. So I'll just share a couple of super quick examples, and then we'll wrap it up. But one example comes from the Keno Indian Nation in Washington. They began working on ongoing workforce development and training to support staff as they learn more about vicarious and secondary trauma and the impact of trauma on treatment court team members. City of Tacoma, Washington, they promoted a safe and welcoming space for treatment court team members to have open conversations after participating in sessions about vicarious and secondary trauma and how to offer each other support. And the Catch Court in Ohio is going to be working to strengthen their steering committee, treatment court team, and advisory group to promote evidence-based practices, ongoing training, and accountability. So, not like I said, we didn't develop implementation recommendations for the last 3 implementation domains because they're a little bit broader and sort of out of, or a lot of aspects of them are out of the control of the court. But I encourage you, if you're not familiar with these domains as they relate to trauma-informed organizations, to take a look again at that 2014 SAMHSA publication to learn more about these last 3 domains as well. So with that, I know maybe a minute or two over, but I just want to really thank TLPI for asking me to do this webinar for you all. I hope you found it informative. I hope you found it beneficial. And like I said, I'm very happy to answer questions after the fact. And I know TLPI will get answers to those questions to you. And encourage you, if you want to follow up with us directly at all, to email at prainc.com. You can also Google SAMHSA's Gain Center if you're not familiar with that. We have a lot of resources on trauma, a whole page dedicated to the trauma-informed responses training that we deliver, and trainers that we train across the country to then train people in their local jurisdictions within their agencies. So there's a lot. I could probably sit down and talk with you for a week about this stuff, but I'm already out of time, so I won't. But I want to thank you again today, encourage you to do your evaluation, because I know that's something that's important, especially to our funder. And I wish you all a good rest of your day, and appreciate your participation. Thank you.
Thanks so much, Chan, for all the information that you shared with us today. And thank you for sticking with us to the end. And of course, we'll have the PowerPoints posted on our wellnesscourts.org site after the webinar, and we will get any questions answered. I also put our wellness email in the chat box in case you think of any after you leave our webinar today. And thank you for the evaluation. The QR code is on the screen, but just thank you so much, Chan. I've actually been a part of some of those SAMHSA trainings and so helpful. And so if there's any interest to see what some of those trainings might be, feel free to reach out to us. I particularly have done the improving criminal justice responses training, and so can help point people in the right direction if any of those are of interest to you. So thank you very much, everybody. Have a great afternoon. Thank you again, Chan. I really appreciate your partnership in providing the information here. Thank you all.
Absolutely. Thanks, Angie. Have a good one.
You too. Bye-bye.